Hey everybody. Since it came up in conversation lately, I thought I'd take this opportunity to read about the Marbury versus Madison case out of Ted Stewart's book, Supreme Power. I think it's a pretty interesting uh, backstory of some of the shenanigans going on even in the earliest days of the founding of our nation, and I think it's kind of indicative of what was to come. It was kind of the first domino to get knocked over, if you will, of a great many other things to be corrupted, perverted, changed, altered, both in our the system erected, but also kind of the political party relationships and people in general. And just thought it was a really interesting representation. And since again it came up, I thought I'd share. I'm not going to read the whole chapter for the sake of time. I don't want this video to end up being too terribly long, but I don't want to exclude too much of the context either. Obviously, if you want the quick and dirty about Marbury versus Madison, Google and Wikipedia will be your friends. But for those of you that kind of would like to know a little bit more about this pivotal Supreme Court case, there's a reason why Stewart included it in his first chapter of his book, obviously, because it kind of paved the way for many to come afterward, like you will learn and hear. But I just wanted to make sure that I might start about halfway into the chapter. That way I don't drop too much of the context, because this is a much more detailed explanation than obviously what Google and Wikipedia are going to give you. But yeah, I don't want it. I'm going to try and keep this under an hour, if at all possible, and read a little bit faster for that reason, but not too fast. But anyway, here we go from Ted Stewart's book, Supreme Power: 7 Pivotal Supreme Court Decisions That Had a Major Impact on America. As the election of 1800 approached, the Federalist Party under John Adams was on the decline, and the Republican under Jefferson were on the ascent. Besides criticism from the outside, the Federalists were being torn apart internally, with Alexander Hamilton, he was a peach, expressing great disappointment with President Adams in a well-publicized writing, calling him eccentric and responsible for nearly destroying the nation. As for the nation as a whole, it was experiencing steady growth. It now consisted of 16 states, and its population had doubled since 1776 to more than 5 million. The territory to the west was being settled. This created challenges for the political contenders. It would still be several decades before it would be deemed proper for candidates to campaign personally. Most electioneering was conducted through hyper-partisan newspapers, pamphlets, and occasional mass meetings. The candidates for both political parties were selected by congressional caucus: John Adams and Charles Pinckney for the Federalists, and Thomas Jefferson and Aaron Burr for the Republicans. I used to live right across the road from where Burr was had killed Burr had been killed by Hamilton. Excuse me. There were issues in Weehawken, New Jersey. There were issues that divided the parties, but they were likely of little import compared to the personal assaults flung about by both sides. There is evidence that principals in both parties consciously decided to put principle aside and go for the jugular, which was unkosher at that time. From the Federalists came the message that Jefferson was an atheist and that his election would show that the nation was in open defiance of God. He was portrayed as not only unfaithful to, but an enemy of Christianity. It was suggested that he was a libertine and had slave mistresses, which David Barton goes into in deep detail in The Jefferson Lies. I highly recommend it. That all morality would be destroyed by a Jefferson victory, and that the chastity of wives and daughters would be lost. That's echoed throughout history. One newspaper posed a key question to be asked by every American laying his hand on his heart as, "Shall I continue in allegiance to God and a religious president, or impiously declare for Jefferson and no God!" Exclamation times 3. Further, Federalists proclaimed Jefferson was too much of a supporter of the French revolutionists, who were still wreaking death and havoc in France. The Federalists asserted that the Republicans were out to destroy both property and religion, as was happening in France, which was true but not fair of an assertion in my opinion, and that they wanted to make the United States a satellite of France. The Federalists claimed that the Republican victory would reduce the United States to a land of groans and tears and blood. From the Republicans came claims that Adams was an autocrat and that the Federalists wanted to make the United States a plutocracy governed by the wealthy of the northern states. The Alien and Sedition Acts were held up as clear evidence of the Federalists' tyrannical laws. It was claimed that war was inevitable if Adams were reelected. They also contended that the Federalists were declared fans of the British Crown and were willing to make the United States an outpost of Great Britain again, which was kind of absurd. Personal attacks were common and usually vicious, even by modern standards. For example, John Adams was later informed that the reason he had lost the state of Pennsylvania was because it was rumored among the large German population there that he had imported 2 mistresses, one French and the other German, and that he had sent the German mistress away, which was ridiculous. That never happened. Another rumor had it that he had sent his vice presidential running mate to London to return with 4 mistresses for the 2 of them to share. Jefferson's supporters alleged that Adams was insane, a lunatic, and quite mad. Despite the ugliness of the campaign, or perhaps because of it, public interest in the election was intense. Upwards of 70% of eligible voters showed up to vote in some areas. The election for president was very close, and ultimately it was thrown into the House of Representatives for the members there to decide. It took 36 ballots and until February 17, 1801, for Jefferson to emerge victorious. As aggressive as the assaults on both sides were, they were apparently sincere. When Jefferson emerged the victor, he genuinely believed that he had saved the country. In turn, the Federalists were convinced that the nation was lost. Besides losing the presidency, the Federalists were soundly defeated in the congressional elections, and the Republicans took control of both houses of Congress. Once the president and the new Congress took over in March, the Federalists were eliminated from power in both the legislative and executive branches. The Federalists were finished as a political party, but not as a force in our nation. The Undelivered Commission. John Adams was not happy to see his colleagues of nearly a quarter of a century replace him, and he was not going to end his presidency gracefully. He refused to attend Jefferson's inauguration on March 4th. In fact, he left Washington at 4 in the morning, 8 hours before Thomas Jefferson was to become the 3rd president. They were once upon a time really deep friends, by the way. He did, however, had the courtesy to send a letter to Jefferson informing him that the horses and carriages at the White House were the property of the United States, and therefore there was no need for Jefferson to supply his own. But missing the swearing in of his successor was the least of the insults aimed at Jefferson and his Republican Party. Just 3 weeks before Jefferson was sworn in, the Federalists, sitting as a lame duck Congress, passed legislation known as the Judiciary Act of 1801. That legislation reduced the number of Supreme Court justices from 6 to 5 just to keep Jefferson from having an appointment in the court. This part of the act was reversed the next year. It also created new district courts and expanded the number of circuit courts and justice of peace positions. In total, it gave the outgoing President Adams 58 judicial positions to fill with Federalist judges, this to complement the existing judiciary, which consisted entirely of Federalists. John Adams named his judges the day before Jefferson was to be inaugurated. The nominations were approved by the lame duck Federalist Congress the next morning, the day of the inauguration. This group became known, quite appropriately, as the Midnight Judges. To complete the process, written commissions had to be delivered to the new judges. This is key for the case coming up. This responsibility fell upon John Marshall, who was then serving the dual role of Supreme Court Chief Justice and Secretary of State. He was a busy man, and somehow 4 of the commissions were never delivered. The naming of the midnight judges was an act that offended Thomas Jefferson mightily. He was later to say that of all the differences and quarrels he had with John Adams, this was the one that wounded him the most. Jefferson ordered that the undelivered commissions remain undelivered. One of those midnight judges was William Marbury, a loyal Federalist. He was confirmed by the Senate on the day of Jefferson's swearing in, but he could not take the oath of office until his commission was delivered. Marbury was thus unable to function as a justice of the peace. He sued the new Secretary of State James Madison for delivery of the commission. Marbury's case was not heard until February of 1803 because the new Republican Congress set about almost immediately to repeal the Judiciary Act of 1801 and prohibited the Supreme Court from sitting until that date in order to assure that the court did not declare the repeal of the Judiciary Act unconstitutional. Thus, a Supreme Court made up of Federalist judges was set to hear a case brought by a Federalist appointee, appointed by a Federalist president, and naming the new Secretary of State, James Madison, perhaps the most prominent Republican next only to Thomas Jefferson as the defendant. The seat of the federal government had moved from Philadelphia to Washington, D.C. in June of 1800. Planning for that move had been underway for a decade. However, it was not until January of the next year that it suddenly occurred to anyone that there was no place for the Supreme Court to meet when it began its term in February. Scrambling officials snatched a small committee room about 24 by 30 feet from the Senate and told the Supreme Court to conduct its business in that room. It did so for the next 8 years. This seeming affront was not unusual for the Supreme Court. It was consistent with the treatment of the federal judiciary generally since adoption of the Constitution 11 years earlier. The only thing that Constitutional Convention hated the most, other than the executive question, was the judicial. In that 11-year period, the Supreme Court saw 4 Chief Justices come and go. The first, John Jay, served for 6 years, but while serving took time off twice to run for governor of New York. He also accepted an invitation from President Washington to travel to England to help negotiate a treaty with Great Britain. The next Chief Justice, John Rutledge, served for less than 1 year, and during that time only 2 cases were decided by the court. The third Chief Justice, Oliver Ellsworth, served almost 5 years. He too was sent off to Europe during his tenure to serve as the head of a delegation to France. In total, prior to John Marshall's court, the Supreme Court had decided only 12 cases. But this inactivity and apparent indolence was just what many of the founders had anticipated, and what most of them truthfully wanted. The question of the need for a national judiciary was not open and shut to many of the founders. Under the governing system prior to the Constitution of 1787, the Articles of Confederation, there were no federal courts except for a single court created to deal with admiralty or maritime issues. To the extent national law was enforced, it was enforced by state courts. It was discovered, however, that such local courts were sometimes loath to trigger the anger of their fellow state citizens when it came to enforcing unpopular federal laws, and their stage left the whole Alien Sedition Act. For example, the treaty that ended the war with Great Britain allowed British creditors to collect debts owed by American businesses and individuals. To do so, those creditors usually had to go to court. The state courts did not take warmly to being called upon to enforce such a treaty right. Among many early Americans, there was a great fear of a federal court system, for good reason. This was true for many reasons, including concerns that the federal courts would upend the power of state courts, might pose a threat to the jury system, and would weaken the power of states to resist federal mandates and power generally. Still, at the Constitutional Convention of 1787, it was agreed that a federal court system was necessary. The Constitution provided for the creation of a Supreme Court. However, The question of how many lower courts there would be and what types of cases they would hear and decide was all left to the judgment of the Congress to assemble after the Constitution's ratification. That Congress dipped its toe ever so lightly into the controversial subject of federal courts. The Judiciary Act of 1789 gave life to the Supreme Court. It also created a handful of the lowest of the courts and district courts. As to the jurisdiction for those courts, it was limited almost exclusively to hearing cases between citizens of two different states. However, the amount of money and controversy between those litigants had to be at least $500, the equivalent of roughly $13,500 today. Thus, the likelihood of a civil dispute being heard in federal court was slim. There were practically no federal criminal statutes. The district courts were not even given jurisdiction to hear all the cases involving enforcement of federal laws. More jurisdiction was given to the circuit courts that were to be made up of one district court judge and two Supreme Court justices. In order for these circuit courts to operate, the Supreme Court justices had to ride circuit, quote unquote, that is, travel to each of the states to conduct trials. But the 1789 Act limited the number of times the federal circuit courts could meet. Along with the limitations on jurisdiction, this removed the threat that these federal courts would usurp the preeminence of the state courts. The preliminary difference between Federalists and the Republicans was over the intended power of the federal government. In the last desperate act to ensure a more vibrant and potent national government, the lame duck Federalist Congress had passed the Judiciary Act of 1801, which created 16 new circuit court judges. The circuit-riding Supreme Court justices were most grateful for that. The act also lowered the threshold for federal civil court jurisdiction to $100. Finally, the act vested in the federal courts the authority to hear and decide all questions of federal law. When the Republicans took control of Congress, they undid much of the 1801 Judiciary Act, including abolishing the new circuit court positions. It was this environment of political warfare and active strife regarding the existence and authority of the federal courts into which Chief Justice John Marshall waded in 1803. Excuse me, I'm going to grab some water. Who was this John Marshall? The man who is uniformly acknowledged to have been the most important Chief Justice in the history of the United States. Marshall was born in Virginia in 1755. He was a distant cousin of Thomas Jefferson through his mother. His father was involved in public life. At age 20, Marshall joined his father's militia unit to fight the British and was later an officer under George Washington, his father's close friend. He was with Washington at Valley Forge. It was his experiences as a soldier, seeing the weak national government fail in its efforts to outfit its army, that led Marshall to the Federalist political party. He believed that the national government had to be strong enough to meet certain basic needs of its citizens, including providing for the defense of the nation. Marshall was close enough to Washington to be deemed his protege. He was part of Washington's headquarters staff, and such proximity to the future president was to prove valuable to Marshall's career. Upon his discharge, Marshall studied law. His prior education was 1 year at a boarding school and 1 year under a tutor. He was brilliant enough that after just 1 year at William and Mary, he was able to begin the practice of law and prove to be successful in that endeavor. He began a political career at age 27 when he was elected to the Virginia General Assembly. As a well-known Federalist, he was in the minority in Virginia, but he was still able to play a significant role at the 1788 Virginia Ratifying Convention. His primary role was to defend the federal judiciary under the Constitution. Specifically, he argued that the federal judiciary would be a defender of the rights of the people through serving as a check on congressional power. He specifically recognized and reasoned that the federal courts would have the power to declare void a law passed by Congress that was a violation of the Constitution. Thus, 15 years before the fact, John Marshall publicly recognized the right of judicial review. This will be very important by the end of this chapter. Marshall practiced law during the Washington years and resisted efforts to enlist him in public service. However, he succumbed to entreaties from President John Adams and served as an emissary for Adams to the French government. This was the beginning of his service at the national level. In 1799, at the personal urging of George Washington, Marshall ran for and was elected to the House of Representatives. He immediately became a source of influence in the Congress because of his moderate views and native intelligence. He remained loyal to John Adams when many of the Federalists abandoned Adams at the urging of Alexander Hamilton. He was named Adams' Secretary of State in May of 1800. The following year, after it was clear that John Adams would be turned out of the presidency, Adams desperately wanted to appoint someone to fill the position of Chief Justice upon the resignation of Oliver Ellsworth. His first choice was his old friend John Jay, who had served before as the nation's first Chief Justice. Jay declined. Marshall later related that he and Adams were discussing the matter when Adams turned to him and asked, quote, "Whom shall I nominate now?" Marshall replied that he did not know, upon which Adams declared, "I believe I must nominate you." One great historian has asserted that in its far-reaching importance to the United States, this appointment was second only to Adams' appointment of George Washington to command the Continental Army 25 years earlier. John Adams gave those two decisions a different prioritization. Quote, "My gift of John Marshall to the people of the United States was the proudest act of my life," end quote. John Adams wanted someone as Chief Justice to serve for a long time. When appointed, Marshall was 45 years old. He was to serve in the position for over 34 years. 1 month after he was sworn in, as a renowned Federalist, he was asked by his cousin Thomas Jefferson to administer the presidential oath to him. Marshall welcomed the opportunity to show that the passage of power from Federalist Party to the Republican Party could occur without rancor. He did not trust his cousin, but he had bowed to the verdict of the people. The Republican Party under Thomas Jefferson was not fond of the federal courts. This animosity was sparked by a number of factors, but included the fact that almost all the federal judges were Federalists. Another reason was the willingness of some of those judges to enforce laws that were truly abominable to the Republicans, specifically the Alien and Sedition Acts. This enmity led to Republican efforts to diminish the influence of federal courts. Those efforts included the repeal of the 1801 Judiciary Act and the suspending of the entire 1802 term for the Supreme Court by the new Republican Congress. One final effort that must be mentioned was the impeachment of Judge John Pickering. After its year-long ban, the Supreme Court was scheduled to return to business in February of 1803. Just a few days before the court was to begin its term, President Jefferson sent a written message to the House of Representatives suggesting that the House consider impeaching a federal district court judge, John Pickering of New Hampshire. Pickering had been named to the district court by George Washington in 1795. By 1800, he was engaging in bizarre behavior. He was accused of being an incurable drunkard and hopelessly insane. No one disputed his inability to serve as a judge, but under the Constitution, a federal judge could be removed only by impeachment. However, the Constitution specifically provided for impeachment for, quote, treason, bribery, or other high crimes and misdemeanors, end quote. Drunkenness and insanity did not fit into any of those categories. Pickering was surely not guilty of bribery or treason. If he were in fact insane, he could not be guilty of committing any crime or misdemeanor under the common law. This was not going to stand in the way of the Republicans, however. With Jefferson's encouragement, the Republican House voted articles of impeachment in March of 1803. Pickering was convicted by the Senate the next year on a party line vote. The message sent by this action was that the Republicans were willing to remove federal judges from office without regard for the actual language or the clear intent of the Constitution. This message must have reverberated among the members of the Federalist bench all the way to the Supreme Court. Among those positions created by the lame duck Federalist Congress and the Judiciary Act of 1801 was that of Justice of the Peace for Washington County in Maryland within the District of Columbia. That position called for a term of office of 5 years. Unlike in modern days, in that era, a Justice of the Peace held a position of great importance. It was the office that most impacted the day-to-day lives of the average citizen in the America of 1800. Justices of the peace then possessed executive, legislative, and judicial powers. Because they made up the legislature for the district's governance, they were like modern-day county commissioners. Justices of the peace also arrested and arraigned criminals and heard major civil cases. They held and advertised lost property and were responsible for assuring public morality. In sum, their duties were substantial, and the position carried with it a great deal of authority and influence within the local community. When named as Justice of the Peace by President John Adams, William Marbury was 38 years old. His father's family had once been wealthy but had lost much of that wealth. Marbury's grandfather had been a Justice of the Peace in Maryland before the family fell on hard times. Marbury was a self-made man. He had aligned himself with the Federalist Party early on. Through his contacts within that party, he had become agent for the state of Maryland and was commissioned to organize Maryland's chaotic finances. This position made him very powerful and quite wealthy. Later, he was the agent of the Naval Yard in Washington, D.C. He became a member of the elite of Georgetown, joined the board of directors of the Bank of Columbia, and grew financially secure through investments and land speculation. When the Federalist Party began to splinter into those who supported John Adams and those loyal to Alexander Hamilton, Marbury remained loyal to Adams. In return for this loyalty, Marbury was one of those men nominated by John Adams and confirmed by the Federalist Senate for Justice of the Peace in the District of Columbia. Marbury had reached the very peak of success, not only in business, but now in politics. Woohoo! But when his commission was not delivered by then Secretary of State John Marshall before Jefferson was inaugurated, that position was snatched from him. Poof! He was not going to give it up without a fight. Marbury hired Charles Lee, former Attorney General for the United States, and sued to obtain delivery of his commission from the new Secretary of State, James Madison. He filed his lawsuit directly with the Supreme Court, seeking, quote, writ of mandamus, end quote, from that court. A writ of mandamus is an order from a court directing a public official to perform a specific act or to do a certain thing. In this case, Marbury wanted the Supreme Court to order the new Secretary of State to deliver the commission to him. Marbury filed his action directly with the Supreme Court because the Judiciary Act of 1789 contained language that specifically allowed the Supreme Court to issue writs of mandamus. Such an action would have been the exercise of original jurisdiction, that is, something that the court would hear argument on and decide as the court of first resort. Original jurisdiction is in contrast to appellate jurisdiction, which is the authority of the Supreme Court to review the actions or the decisions of lower courts and decide whether or not those lower courts acted properly. Because the Supreme Court was hearing the case in the first instance, it had to conduct a trial. Witnesses were called and examined before the court, and additional witnesses submitted affidavits or sworn testaments in support of Marbury's case. Ironically, one of those witnesses was James Marshall, the brother of the Chief Justice, who had been acting as a courier for the State Department in the delivering of commissions. The Supreme Court heard oral arguments and made its unanimous decision on February of 1803. In that decision, authored by Chief Justice John Marshall, the court decided 4 questions. First, did Mr. Marbury have the legal right to the position of Justice of the Peace for Washington, D.C.? The court said that indeed he did. It concluded that once the president had signed the commission, as John Adams had done, Marbury was entitled to the office. The second question asked and answered by the court was, if Marbury is entitled to the office, does he have a remedy under the law? This question was easily answered, for, as Chief Justice Marshall stated most emphatically, the government of the United States is a government of laws and not of men. If the United States were a nation of laws, there absolutely had to be a legal remedy to protect a legal right. The third question asked and answered was this: if Mr. Marbury had a legal right to the position of Justice of the Peace, and since a legal remedy did exist, was that legal remedy a writ of mandamus issued by the Supreme Court of the United States ordering James Madison to deliver the commission? The answer to that question held a bit more peril for the Chief Justice. As had already been described, the Supreme Court was a focal point of the contentious politics of its day. Jefferson had already concluded that the Federalist judiciary was a threat to his presidency and the Republican Party. In a private letter, he asserted the view with some annoyance, quote, on their part, they have retired into the judiciary as a stronghold. There, the remains of federalism are to be preserved and fed from the treasury. And from that battery, all the works of republicanism are to be beaten down and erased. End quote. If the Supreme Court asserted the right to tell Jefferson's executive branch officers what to do or not to do by way of the issuance of mandamus, Jefferson's fears would be realized. The court concluded that the writ of mandamus was in fact the correct legal remedy. Marshall made it clear, however, that the courts could not issue writs of mandamus in matters that were purely discretionary for executive branch participants. He said, quote, the province of the court is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. End quote. One can only imagine that as William Marbury read this opinion on this point, his hopes had been high. He likely would have felt confident that he was indeed going to finally receive the position that the Republicans had deprived him of. However, there was a fourth question that the Supreme Court had to decide, and that was whether it was for the Supreme Court to issue the writ of mandamus. To the chagrin of Mr. Marbury, the court said no, and in doing so issued the judgment that a later Chief Justice of the Supreme Court said was, quote-unquote, the most famous decision ever issued by this United States Supreme Court. The unanimous court concluded that in attempting to vest in the Supreme Court the power to issue a writ of mandamus, as Congress had done in the Judiciary Act of 1789, the Congress had acted unconstitutionally. It reasoned that Article 3 of the Constitution gives the Supreme Court original jurisdiction only in very specific cases affecting foreign ambassadors and cases in which a state itself is a party. Those are the only types of cases that can begin and end in the Supreme Court. The Supreme Court's remaining jurisdiction is appellate jurisdiction, that is, the right to hear and decide appeals from lower courts. Because the Constitution is so clear on the limitation of original jurisdiction, the Congress had violated the Constitution in attempting to expand the court's original jurisdiction. In reaching that conclusion, the Marshall opinion said something that is clear to us today, but that needed to be said with authority and precision in those early days of the new and untested American experiment in self-government. That something was that the Constitution was the fundamental and paramount law of the nation. The Congress could not change the Constitution by passing ordinary legislation. Yeah, they don't agree. They don't abide by that now. Neither does the Supreme Court, for that matter. Because this was so, any law passed by the Congress and signed by the President that was in violation of the Constitution was void, invalid, of no force. The Constitution had to triumph over any normal legislative act of Congress or the President. The court was not done. In stating the preeminence of the Constitution over legislative and executive acts, the question arises, who gets to decide when and whether such an act is in violation of the Constitution? To this, the Marshall opinion said, quote, "It is emphatically the province and duty of the Judiciary Department to say what the law is," end quote. It went on to state that if the Constitution and a law conflict with each other, the courts must decide between the two. The courts cannot close their eyes to the unconstitutionality of legislative acts. This was, in fact, quote, "the very essence of judicial duty," end quote. Thus was born, to forever rule the American scene, the power of judicial review. That is, the United States Supreme Court is the final arbiter, the ultimate authority, the deciding voice of constitutional questions. Did the Founding Fathers anticipate a Supreme Court that would triumph over the executive and legislative branches? History shows that the feared showdown between John Marshall and his cousin Thomas Jefferson was avoided. Marbury did not get his commission. He went on with his life. Further, the feared domination of the Republican Congress and presidency by the Federalist judiciary did not materialize. The ultimate conclusions of the court, that the Constitution was paramount and that the courts got to decide whether and when a law violated that Constitution, were not terribly controversial. Since 1803, some have argued that John Marshall created a right for the court that was never contemplated by the founders, that the power of judicial review was made up out of thin air. Such is simply not true. It's not entirely untrue either. There is substantial evidence that this duty of the courts existed in the English common law system. At the Constitutional Convention, it had been observed that the courts would have the right to void unconstitutional laws. This was, in fact, one of the selling points to those who feared the growth of national power and a potentially out of control Congress. The best evidence that judicial review was contemplated by the founders is to be found in the Federalist number 78. I highly recommend reading that, though I won't bore you with that here, in which Alexander Hamilton argued quite clearly that it would be the responsibility of the courts to rein in excessive and unconstitutional acts of the legislative branch. It was also pointed out that without such power in the courts, they would not be able to exercise a check required by the checks and balance system, ingeniously envisioned by the founders. There was also at least one Supreme Court decision prior to Marbury in which the court had determined a separate constitutional act to be invalid. Additional evidence that the Marbury decision was not exceptional is suggested by the reaction to that decision in 1803. The opinion received scant notice in the press. The case was reported on, but it was not criticized or characterized as earth-shaking. Even Thomas Jefferson did not pay much attention to that part of the Marbury decision in which the court declared that it is the duty of the court to say what the law is. In the decades that followed, there were only a handful of critical comments made regarding the power assumed by the Supreme Court. No The authority of the courts to decide issues of constitutionality, now referred to as the power of judicial review, was not hotly debated in the decades after the Marbury decision. In part, that may be because the Supreme Court did not exercise its appointed power for over 50 years. The next time it found a legislative act to be unconstitutional was in the Dred Scott decision of 1857. Personal note, which was a total flippin' disaster. This is where the Supreme Court started to go completely off the rails of the precedent that Marshall and his company had put in precedent. Or in order. But anyway, I digress. The issue that did generate heat was the question of whether the Supreme Court of the United States had that duty and power alone, or whether it was a duty and power shared with both the executive and legislative branches. Subsequent to the court's decision, President Jefferson did not criticize his cousin's assertion to the power of judicial review. He simply asserted that the Supreme Court did not have the right to decide on the constitutionality of a matter for the president, just as the president did not have the right to decide on the constitutionality of a matter for the judiciary. James Madison, often designated as the father of the Constitution, mainly because he wrote the majority of the Federalist Papers, had argued before the House of Representatives in 1789, that though it was true the judiciary had the responsibility for clarification or interpretation of the Constitution, such power was not greater than that possessed by the other branches of government. Water break. Two of the influential presidents in the decades following Jefferson, Andrew Jackson and Abraham Lincoln, generally shared Jefferson's view of the shared authority. As good as the theory of shared responsibility may sound, it has no practical effect, I'll say. Time has proven that out. It should be presumed that members of the legislative branch and the executive branch conscientiously consider the constitutionality of every piece of legislation we would hope that they would vote on or sign. All the men and women who occupy those positions take an oath to support and defend the Constitution of the United States. Still, they pass legislation that courts find to be unconstitutional. That is also true of state legislators and governors. As a practical matter, although arguments are still made from time to time that the exercise of review of legislative acts is to be shared, those arguments have no effect or force. Such arguments are basically lost in history. It is a current reality that the ultimate authority on the Constitution of the United States is the Supreme Court of the United States, and the Supreme Court alone. It is quote-unquote supreme in both name and clout. It is important to note that John Marshall understood there to be limits to court power of judicial review, which that was still upheld today. In the Marbury opinion that he authored, the Chief Justice emphasized those limits, quote, questions in their nature political, or which are, by the Constitution and laws submitted to the executive, can never be made by this court, end quote. It appears that one of the reasons that the power of judicial review was not exercised by the Supreme Court for over half a century was because members of that court honored this view, that they ought not to second-guess political and policy decisions made by the other two branches. But restraint in this area was not to last. In the second exercise of judicial review, in the 1857 Dred Scott decision, which Stewart, by the way, has a whole other chapter where he goes into the details of this and how bogus it was as far as how that decision played out. And the Chief Justice, I believe his name was Black, who was a scoundrel some gun who, I advise you check out that chapter of this book as well about the Dred Scott decision. Anyway, the Supreme Court waded fully into the political swamp. It declared unconstitutional an act of Congress, the Missouri Compromise of 1820. The Supreme Court also made the purely political decision that Americans of African descent could never be citizens of the United States, and that the Congress had no authority to regulate the issue of slavery in the territories of the United States, despite the Missouri Compromise of 1820. Thereafter, the floodgates for the courts to exercise judicial review in the last half of the 19th century. As noted, prior to 1860, the Supreme Court had ruled only 2 acts of Congress to be unconstitutional. Between 1865 and 1898, it held 21 acts of Congress to be in violation of the Constitution. Not only did the Supreme Court exercise its authority more frequently, but the nature of the types of legislation it found to be unconstitutional became more and more controversial. The courts of the United States, both state and federal, exercised little restraint on the types of cases they would hear and the acts of legislative bodies that would be declared invalid and unconstitutional. In the 21st century, the power of the Supreme Court to judicially review legislation passed by Congress and the states, and to declare that legislation unconstitutional, void, of no effect, and invalid, has become unchallenged. Every decision that will be analyzed and discussed hereafter is an example of the exercise of judicial review. Sometimes the Supreme Court voided state or federal legislation. Sometimes it approved or endorsed review that is vested in the Supreme Court has shaped, molded, and reworked the United States of America, which he is absolutely 100% true and accurate in that statement. I highly recommend y'all read the rest of this book. That's the end of chapter 1, if you so choose. I found it to be at least one of the half dozen books that I have read over the years that was just highly educational and informative. If you want to learn some of the reasons behind why our nation is currently in the muck and mire and sort of in the mud in so many different regards, this book will at least reveal one course that brought us there. And that is how the black-robed demigods on the bench of the Supreme Court have, over the years and over the centuries, particularly from the mid-1800s till now, have decided to catapult themselves away from being solely focused on constitutional matters and sort of throwing in their opinions and their hats in the political ring, if you will. There is a great quote in this book, maybe I can find it in mine because I included it in mine, that I think outlies the warning that was given by, I think his name was Judge Yates, about the potential dangers that was being hashed out in the Constitutional Convention about what they were fixing to vest the powers in the Supreme Court. Because unfortunately, because the country was so fixated on the King of England, what you'll find when you study the hot topic, if I can interject some opinion here, and then I'll turn this video off. The hot topic of debate, what was bringing people to fisticuffs in the Constitutional Convention, and the only reason I think it didn't lead to murder was because George Washington was sitting there sweating his brains out, and everybody respected him and didn't want to act too badly in front of him, but they were all duking it out over the executive branch. So that was kind of their main area of focus, and fears of investing too much power into the executive branch. However, if I can just read this little section from Forbidden History, my history book, if you will, on page 54, in a series of letters published in the New York newspaper between October 1787 and April of 1788, Judge Robert Yates, writing under the pseudonym Brutus, wrote, quote, "It is moreover, of great importance to examine with care the nature and extent of the judicial power, because those who are to be vested with it are to be placed in a situation altogether unprecedented in a free country. No errors they commit can be corrected by any power above them, nor can they be removed from office for making so many erroneous adjudications. End quote. 2 months later, he wrote more forcefully and urgently, quote, there is no power above them to control any of their decisions. There is no authority that can remove them, and they cannot be controlled by the laws of the legislature. In short, they are independent of the people, of the legislature, and of every power under heaven. Men placed in this situation will generally soon feel themselves independent of heaven itself. My question for you, the reader, is, did Judge Taney prove to the worry and concern of Yates to be entirely accurate, or simply seeing shadows in a boogeyman that did not exist? If you are unsure, reading Supreme Power by Ted Stewart should help clarify. So anyway, the point is if you guys want to read how much of our genetic makeup has been so drastically altered throughout the history, particularly from mid-19th century till now, please read Stewart's book. Chapter 1 is about Marbury versus Madison. Then he goes into Plessy versus Ferguson of 1896, Lochner versus the state of New York in 1905, Wickard versus Filburn in 1942, Everson versus the Board of Education of Ewing Township, which was a big one, in 1947, Missouri versus Jenkins, and of course, Obergefell versus Hodges in 2015. So these are the 7 court cases that he writes about that had such a massive, massive impact on changing the national morality, ethical point of view, politics, legislative, high jumps that occurred after them. Like they just had such a massive, massive impact, which makes Judge Yates's warning all the same. But anyway, there it is. Marbury versus Madison. Tried to keep this under an hour, and I hope that was informative for anybody interested in learning more about the case that begun it all as far as the United States Supreme Court. So take care, shalom, goodbye.